The fastest way to destroy a $24 million resort is to build its biggest promise on land you never owned. I did not know that truth would become my reality until I watched a boat full of smiling tourists step onto my private island carrying matching wristbands with the logo of the local Homeowners Association. At first I honestly believed they had made a simple mistake. My island sat just beyond the marina, surrounded by calm blue water and protected by clearly marked property boundaries that had existed for decades. I had owned it for years, maintained every dock, every trail, and every shoreline myself. No one had ever questioned who owned it because every recorded document pointed to the same answer. Yet that Saturday morning, strangers were walking across my beach as if they had purchased the right to be there. I approached the tour guide politely and asked who had organized the trip. She smiled, pointed toward a glossy brochure, and said the Homeowners Association had recently expanded its premium island experience package for guests staying at the new luxury resort opening the following week. I asked whether she realized the island was privately owned. Her expression immediately shifted from confidence to confusion. She pulled out a laminated instruction sheet that listed my island as one of the resort's exclusive amenities available to paying visitors. I thanked her, wished everyone a pleasant afternoon, and quietly returned to my boat. Getting angry would not answer the question already forming in my mind. How had my property become someone else's business opportunity? Back at my office overlooking the marina, I searched the resort's website. My stomach tightened as I found professionally produced videos showing families kayaking around my shoreline, couples enjoying sunset walks across my beach, and promotional graphics describing unrestricted access to what they called the community's private island retreat. The videos had already attracted thousands of views. Reservation calendars showed the resort nearly fully booked for its grand opening in just 9 days. I drove directly to the sales center pretending to be a prospective buyer interested in purchasing a vacation package. Large display models highlighted the marina, luxury villas, restaurants, and the island experience as the signature attraction separating this development from every competing resort along the coast. A sales representative proudly explained that guests would enjoy exclusive access unavailable anywhere else in the region. I asked who owned the island. Without hesitation, she replied that the Homeowners Association managed everything beyond the marina under long-established community rights. I thanked her, collected every brochure I could find, and walked back outside. Something about that answer felt rehearsed rather than verified. Before leaving, I noticed Patricia Collins speaking with investors beside an enormous rendering of the completed resort. She confidently described the island as the centerpiece of the entire project, while pointing toward my property on the display map. She looked completely certain that everything had been approved years earlier. I never interrupted her presentation because I wanted to understand how far this misunderstanding actually reached. That evening I unlocked the fireproof cabinet containing every original deed, survey, title policy, coastal permit, and county filing connected to my island. The documents had not moved since the day I purchased the property, but as I carefully spread them across my desk, one question refused to leave my mind. If every legal record proved I owned the island, what document had convinced an entire resort that it belonged to someone else? 8 days remained before the resort's grand opening, and every hour made the situation more dangerous than the one before it. I arrived at the county recorder's office as soon as the doors opened because I wanted certified answers instead of assumptions. My original deed matched the official county record exactly. The legal description of my island had never changed. No easement, no access agreement, no transfer, and no recorded covenant connected my property to the Homeowners Association or the neighboring resort. That should have ended the mystery, but instead it created an even larger one. If the legal records were perfectly clear, how had an entire multimillion-dollar development built its biggest attraction around my island? My next stop was the title company that had handled my purchase years earlier. The senior examiner remembered the transaction because privately owned islands rarely changed hands. She retrieved the archived title file and carefully reviewed every recorded instrument affecting the property. After nearly an hour, she looked up and quietly confirmed exactly what I already suspected. My title remained clean. No document had ever granted public access, resort access, marina access, or Homeowners Association authority over the island. Before I left, she handed me certified copies of every recorded filing and suggested I compare them with the planning records used during the resort's approval process. That advice led me directly to the county planning department. A planning technician displayed the current development maps used by several agencies. The moment my island appeared on the screen, I noticed something that immediately caught my attention. A colorful planning layer shaded my island with the same color as the resort property. I asked whether that meant ownership had changed. The technician quickly shook his head and explained that planning maps often illustrated proposed development concepts rather than legal ownership. He then opened the official parcel layer used for taxation and recorded property boundaries. This time my island appeared exactly where it belonged, completely separate from the resort. Two county systems were displaying two different realities. One reflected the recorded law. The other reflected the resort's planning documents. I asked which map had been used when the resort advertised island access. The technician hesitated before admitting that developers frequently relied on planning exhibits during marketing presentations because those graphics were easier for buyers to understand. That answer explained how the mistake had spread, but not where it began. Before leaving, I requested copies of every planning exhibit connected to the resort application. While the technician searched the archives, another employee quietly mentioned that the original coastal development proposal had gone through several revisions years earlier. Most people never requested those older versions because only the final approval usually mattered. I immediately asked for every revision that still existed. Nearly 40 minutes later, a large stack of oversized maps arrived from storage. As I compared them one by one across a conference table, I noticed something impossible to ignore. The earliest concept drawings showed my island inside the resort boundary with a dotted line labeled future recreational access. Several later revisions removed that notation entirely. Then, without explanation, one much newer marketing exhibit added the island back into the project using a completely different graphic style than every official planning map surrounding it. I stared at the pages for several minutes before asking the technician whether that exhibit had ever been approved by the county. He studied the document, compared it with the approval stamps on the other records, and slowly frowned. He admitted he had never seen that version before. As he picked up the telephone to call the county planning supervisor, I realized the mystery had just changed completely. The question was no longer whether I owned my island. The question had become who had inserted that unexplained map into a $24 million resort project only days before its grand opening. 7 days remained before the grand opening, and the closer the celebration came, the more I realized this was no longer a simple property dispute. It had become a race between the truth and a marketing campaign that had already convinced thousands of people to believe a story that did not exist. Before the county planning supervisor returned my call, I hired two professionals whose opinions could not be dismissed as personal interest. The first was a maritime surveyor with decades of experience documenting coastal boundaries. The second was a real estate attorney who specialized in title disputes involving waterfront property. Neither of them knew anything about the resort, or the Homeowners Association before I explained what I had discovered. By late morning we were standing on the highest point of my island overlooking the marina. The surveyor compared satellite positioning equipment with the original boundary monuments that had been placed years earlier. Every measurement matched the recorded survey within inches. He smiled and said there was no ambiguity whatsoever. My island had never crossed into the neighboring development, and the neighboring development had never crossed into my island. The attorney then reviewed the certified county records I had collected the previous day. He highlighted every reference to recorded ownership, every legal description, and every easement affecting nearby parcels. After nearly 2 hours of careful review, he placed the file on the table and quietly said something that changed the entire direction of my investigation. He explained that if the resort had sold vacation packages promising access to my island without a recorded legal right, the problem extended far beyond my property. Buyers had relied on representations that could expose multiple parties to significant legal consequences. That single observation made me reconsider everything. The island was not merely one attraction among many. It appeared throughout advertisements, promotional videos, reservation materials, and investor presentations as the defining feature separating the resort from competing destinations. I returned home and searched archived versions of the resort website captured over several months. Every update expanded the promises surrounding the island experience. Premium packages included guided nature walks, private picnic reservations, sunset photography tours, and exclusive shoreline access. None of those promises mentioned my ownership or any agreement with me because no agreement existed. That afternoon, the county planning supervisor finally invited me back to his office. He had reviewed the questionable planning exhibit and admitted something that surprised everyone in the room. The exhibit containing my island had never appeared in the official approval package preserved in the county archive. Instead, it existed only inside a supplemental presentation file submitted later during marketing coordination meetings. He stressed that planning exhibits were never intended to alter ownership rights, yet someone had continued treating that unofficial illustration as if it represented legal authority. Before I could ask another question, the supervisor received a call from the county archive division. They had located an older storage box containing development records that had not been digitized because they predated the current electronic filing system. We walked downstairs together while an archivist carefully opened the sealed container. Inside were handwritten review notes, engineering sketches, correspondence between consultants, and one missing routing sheet that had disappeared from every digital copy. The supervisor unfolded the aging document and immediately became silent. Across the top margin, someone had written a short instruction stating that all references to recreational access across my island were to be removed because no legal rights had ever been granted by the owner. Everyone around the table exchanged confused looks because that instruction should have ended the issue years earlier. Instead, somewhere after that warning was written, someone had managed to put the island back into the resort story, and we still had no idea who had made that decision or why. 5 days remained before the grand opening, and for the first time I realized the biggest threat was not the Homeowners Association. It was time itself. Every reservation that remained active, every advertisement that stayed online, and every investor presentation that repeated the same promise increased the damage waiting to happen. The county planning supervisor called me early that morning and asked whether I could return immediately because the archive staff had discovered another collection of records connected to the original Coastal Review. When I arrived, several employees were already comparing paper files with digital scans projected onto a large monitor. At first glance they appeared identical, but after several minutes the differences became impossible to ignore. A page included in the digital file was completely absent from the original paper archive, while an internal review memorandum found inside the archive had never been scanned into the electronic record. The missing memorandum contained a direct recommendation that all promotional materials must accurately distinguish between privately owned property and community amenities in order to avoid misleading future buyers. The planning supervisor quietly admitted that if this recommendation had been followed, none of the current problems would exist. That discovery answered one question but immediately created another. Why had the warning disappeared while the unofficial map continued spreading through marketing materials? My attorney suggested requesting every communication exchange between the resort consultants, the Homeowners Association, and the planning department during the approval process. Although many documents were protected, several meeting summaries were available through public records. We spent the afternoon reading hundreds of pages. Most discussions focused on parking, stormwater management, landscaping, and marina construction. Then one brief meeting summary changed everything. A consultant had asked whether the island experience could remain in promotional materials even though legal ownership belonged to a private individual. The response recorded by the meeting secretary was simple. Any future marketing must avoid implying ownership or guaranteed access unless supported by a separate legal agreement. There was no evidence that such an agreement had ever existed. My attorney leaned back in his chair and explained that someone had ignored a direct warning instead of correcting the advertisements. Later that afternoon I decided it was finally time to speak with Patricia Collins. I requested a meeting at the Homeowners Association office without mentioning everything I had already discovered. She welcomed me with complete confidence, and immediately insisted that the community had promoted the island for years without complaint. I calmly asked her to show me the document granting the Homeowners Association authority over my property. She opened several folders, searched through printed maps, and eventually produced the same colorful planning exhibit I had already seen at the county office. I asked whether she possessed a recorded deed, easement, or signed access agreement. Her confidence faded slightly before she replied that the consultants had assured everyone the planning documents reflected approved community rights. I thanked her for her time and left without revealing the certified records waiting inside my attorney's office. I wanted to understand whether she truly believed the consultants, or whether she had simply never verified their claims. As I reached the parking lot, my telephone rang. It was the county planning supervisor. His voice sounded more serious than ever before. During another review of archived correspondence, the staff had located an email printed years earlier because the original electronic account had been closed. The message warned that one specific presentation map contained inaccurate property information and should never be distributed outside internal planning discussions. The supervisor paused before telling me the final detail. According to the distribution list attached to that email, Patricia Collins had received the warning years before the resort ever sold its first vacation package. 3 days remained before the grand opening, and every new piece of evidence seemed to reveal an even larger problem hiding beneath the last one. I spent the morning inside my attorney's conference room surrounded by certified deeds, archived planning files, survey reports, historical aerial photographs, and printed advertisements collected from the resort's own website. Individually, none of them explained everything. Together, they told a story that no one involved could easily dismiss. The advertisements promised guests private shoreline access, guided island tours, exclusive nature experiences, and sunset events on property that legally belonged only to me. My attorney organized the documents into a timeline stretching back more than a decade. At first, the island appeared only as a nearby scenic landmark. Later marketing materials described it as an optional attraction. Then, almost without explanation, every premium package began presenting it as a guaranteed resort amenity. Somewhere during that transition, assumption had quietly become certainty. We decided it was time to determine whether the resort itself understood the legal risk it faced. My attorney sent a formal notice to the resort's legal department explaining that I possessed certified ownership records proving the island had never been transferred, dedicated to public use, or placed under the authority of the Homeowners Association. We requested an immediate meeting before the scheduled opening. Less than 2 hours later, the resort's outside counsel called back. His voice sounded professional, but I could hear genuine concern beneath every carefully chosen word. He admitted this was the first time anyone had presented certified ownership records directly contradicting the promotional materials. He asked whether I would postpone any legal action while they conducted an internal review. I agreed because my goal had never been to create chaos. I simply wanted the truth established before thousands of visitors arrived expecting something that had never legally existed. Late that afternoon, another unexpected discovery changed the situation again. The county planning supervisor forwarded copies of archived coastal permit correspondence that had recently been located in an off-site storage facility. Buried inside the file was a review letter from the state coastal agency explaining that the resort's marina approval had been evaluated under the assumption that guest recreation would remain within property legally controlled by the developer. The letter specifically noted that access to neighboring private property would require separate legal authorization before being represented as an available amenity. There was no record that such authorization had ever been submitted. My attorney immediately understood the significance. If the resort's signature attraction depended upon access that had never been legally secured, then the issue extended beyond advertising. It could affect representations made during the permitting process itself. Before we could discuss our next step, another email arrived from the resort's legal team. They requested an emergency meeting the following morning and asked me not to contact investors or reservation holders until they completed their internal investigation. That request alone told me they had finally realized how serious the situation had become. As the sun began to set over the marina, I looked across the water toward my island, still peaceful despite everything unfolding around it. The boats carrying tourists had stopped for the day, but construction crews continued working at the resort, completely unaware that the future of the entire project might depend on documents sitting inside my attorney's office. Just as I prepared to leave, my attorney received electronic notice that the county court had granted our request for an expedited hearing less than 48 hours before the grand opening, and for the first time, every decision made by the Homeowners Association, the resort, and everyone behind those promotional promises would have to be defended under oath. 2 days remained before the grand opening, and the courthouse was far quieter than I expected for a hearing that could determine the future of a $24 million resort. My attorney reminded me that this was not a trial about emotions or assumptions. It was a hearing about jurisdiction, recorded property rights, and whether the Homeowners Association had any legal authority to sell access to land it did not own. Patricia Collins entered the courtroom with the same confidence I had seen at the sales center, surrounded by attorneys, consultants, and several resort executives. They appeared convinced that decades of community practice would outweigh a stack of property records. I remained calm because the facts had not changed since the day I purchased the island. When the hearing began, the judge asked a simple opening question that immediately focused the entire case. He requested that the Homeowners Association identify the recorded legal instrument granting authority over my island. Patricia's attorney confidently approached the bench carrying several binders filled with planning exhibits, marketing presentations, community maps, and development summaries. One by one, the judge reviewed each document before asking the same question again. Was there a recorded deed, easement, covenant, or other legally recorded instrument transferring ownership or granting permanent access rights? The courtroom became noticeably quieter. The attorney admitted that no recorded deed existed but argued that long-standing planning documents established the community's reasonable understanding. My attorney immediately responded by presenting certified copies of the county recorder's records, the original survey, the title policy, and the uninterrupted chain of ownership. Every document pointed to the same conclusion. My island had remained private property from the beginning, and no recorded instrument had ever changed that status. The judge carefully compared the certified records with the colorful planning exhibit that had appeared throughout the resort's advertising. He then asked the county planning supervisor to explain the difference between an illustrative planning exhibit and a recorded property document. The supervisor testified that planning graphics were created to communicate development concepts and were never intended to modify ownership rights. He also confirmed that the exhibit showing my island as part of the resort had never been approved as a legal property record. That testimony changed the atmosphere inside the courtroom. Several resort executives quietly exchanged concerned looks while their legal team reviewed documents at the counsel table. Then my attorney introduced another piece of evidence that no one outside our preparation had expected. He presented the archived review memorandum instructing planners to remove all references to recreational access across my island because no legal rights had ever been granted by the owner. The judge read the memorandum carefully before asking whether anyone disputed its authenticity. No one did. Patricia appeared genuinely surprised as she looked toward her own attorneys, who seemed to be seeing the memorandum for the first time. For the first time since this dispute began, her confidence gave way to uncertainty. The judge announced that the certified ownership records strongly favored my position but explained that one important question still remained unanswered before he could issue a final ruling. Someone had continued promoting island access years after written warnings had instructed otherwise. Determining who had authorized that decision could affect responsibility for everything that followed. As the hearing concluded for the day, the judge ordered every party to produce all remaining internal communications connected to the disputed marketing materials before court resumed the next morning. Just as we stepped outside the courthouse, my attorney received notice that one additional archive box had been located overnight, and according to the county clerk, it contained the original approval signatures for the very presentation map that had started this entire dispute. 1 day remained before the grand opening, and I finally understood why the truth had stayed hidden for so many years. It was not because the documents had disappeared. It was because almost nobody had ever compared every version side by side. Early that morning my attorney and I met the county clerk to examine the newly discovered archive box ordered into evidence by the judge. Inside were original routing sheets, consultant correspondence, approval logs, and presentation materials that had never been digitized. Every page was carefully dated, signed, and organized. As we reviewed the records, one document immediately stood out. It was the original approval sheet for the presentation exhibit that eventually appeared in the resort's investor meetings. Unlike the certified planning documents, this sheet contained no county approval stamp authorizing it for public use. Instead, a small notation identified it as a conceptual marketing exhibit prepared by a private consulting firm. The county planning supervisor compared the signatures on the routing sheet with official approval records preserved in the permanent archive. Within minutes he identified a critical difference. The signature approving distribution of the presentation exhibit did not belong to any county official responsible for land records or development approvals. It belonged to a marketing consultant hired during the resort's early promotional campaign. That single discovery changed everyone's understanding of the case. The island had never become part of the resort through a government decision. A private marketing illustration had gradually been treated as if it carried the same authority as a recorded legal document. By the time court resumed later that afternoon, the atmosphere inside the courtroom was completely different from the day before. The judge reviewed the newly discovered routing sheet while the county planning supervisor explained the chain of document approvals in careful detail. He testified that conceptual graphics could be useful during early planning discussions but could never alter recorded ownership or create legal access rights. The judge then asked whether any county employee had ever approved public marketing claiming guaranteed access to my island. The supervisor answered with a clear and unmistakable no. My attorney followed by presenting archived advertisements showing that the resort continued promoting exclusive island access years after written warnings instructed developers to avoid those claims without a separate legal agreement. The resort's legal counsel acknowledged that the marketing materials had relied upon consultant presentations rather than independently verified property records. Patricia Collins remained silent through most of the hearing. When the judge finally asked whether she had personally verified the ownership documents before allowing the Homeowners Association to promote island access, she quietly admitted that she had trusted the consultants because the presentations had been used for years without challenge. Her answer revealed something important. Confidence had replaced verification, and assumptions had replaced legal proof. Even so, the judge explained that good faith alone could not create property rights where none existed. Before concluding the hearing, he announced that the certified ownership records, the archived planning memoranda, the routing sheet, and the testimony presented thus far all pointed toward the same legal conclusion. However, because the ruling would affect multiple parties and substantial financial interests, he would issue his final decision the following morning before the scheduled grand opening ceremony. As everyone slowly left the courtroom, I looked across the parking lot and saw resort staff still hanging banners welcoming hundreds of arriving guests. They had no idea that before the first ribbon could be cut, one final ruling would determine whether the attraction at the center of every advertisement would disappear overnight. The morning of the grand opening arrived with television crews setting up cameras outside the resort, while guests filled the marina expecting a celebration that had taken years to build. At nearly the same moment, the courtroom filled with attorneys, county officials, investors, and representatives from the Homeowners Association. The contrast could not have been greater. Outside, banners promised unforgettable experiences. Inside, every promise was about to be measured against recorded facts. The judge entered, reviewed the final filings submitted overnight, and immediately addressed the central issue that had remained unchanged from the beginning. He explained that ownership of real property could not be created through marketing materials, conceptual planning exhibits, or years of mistaken assumptions. It could only be established through legally recognized property records and recorded instruments. He then summarized the evidence one final time. The uninterrupted chain of title confirmed that my island had always remained private property. Certified surveys matched every recorded legal description. The county planning department confirmed that the disputed presentation exhibit had never been approved as a legal property document. Archived memoranda proved that planners had specifically instructed developers to remove references suggesting public or community access. Finally, the routing records demonstrated that the illustration relied upon throughout the resort's advertising had originated from a private marketing consultant rather than any county authority. After reviewing those findings, the judge concluded that the Homeowners Association had never possessed the legal authority to sell, advertise, license, or represent access to my island. He ordered the Homeowners Association to cease all claims suggesting control over the property, and directed that every inaccurate representation be removed immediately. The courtroom remained silent as the ruling settled over everyone present. Then attention shifted toward the resort. Its legal counsel informed the court that management had already suspended every promotional activity involving the island after reviewing the evidence presented during the hearing. Investors sitting quietly behind the attorneys exchanged worried looks while several executives stepped into the hallway to make urgent telephone calls. News traveled much faster than anyone expected. Before we even left the courthouse, guests arriving for the grand opening began receiving revised activity schedules explaining that several advertised experiences would no longer be available. Local reporters gathered outside the courthouse asking county officials to explain how such an expensive development could have relied upon property it never controlled. The planning supervisor answered carefully, emphasizing that official records had always reflected the correct ownership and that the dispute resulted from inaccurate promotional materials rather than government approval. As I walked toward my truck, my attorney received another message from the resort's legal team. They requested an immediate meeting that afternoon to discuss resolving every remaining issue without additional litigation. Their tone was completely different from our first conversation only days earlier. Instead of defending assumptions, they now wanted to negotiate practical solutions based upon the court's findings. Across the harbor, workers quietly removed banners featuring the island while guests watched with confused expressions from the marina docks. The celebration everyone had anticipated had changed into a day of difficult explanations and emergency meetings. Yet even after the judge's decision, one important question still remained unanswered. The ruling established who owned the island and who lacked authority to market it, but it did not determine who would ultimately bear responsibility for the financial consequences created by years of promises that should never have been made in the first place. The final chapter of this story did not end with someone losing an argument. It ended with everyone finally accepting the truth that had been sitting inside the county records all along. Later that afternoon, my attorney and I met with the resort's legal team inside a quiet conference room overlooking the marina. The mood was completely different from our first meeting only days earlier. No one argued about ownership anymore because the court had settled that question. Instead, they focused on repairing the damage created by years of inaccurate assumptions. The resort agreed to remove every brochure, website advertisement, promotional video, and reservation package claiming guaranteed access to my island. Investors demanded an independent review of every marketing representation used during the development process, while the board ordered new compliance procedures requiring future promotional materials to be verified against recorded property records before publication. The Homeowners Association also faced its own consequences. During its next board meeting, members openly questioned how such an important claim had been accepted without reviewing a single recorded deed or certified survey. Patricia Collins stood before the community and admitted that she had relied on consultant presentations instead of independently confirming the legal documents. She acknowledged that confidence had replaced verification and that the mistake had continued because no one stopped to ask the simplest question of all. Who actually owned the property? Within days, she resigned as president, and the board elected new leadership committed to reviewing every policy involving property rights and community authority. The county planning department also updated its procedures. Officials added clearer disclaimers to conceptual planning exhibits, so they could never again be mistaken for legal ownership records. Training sessions were expanded to remind developers, consultants, and community associations that planning graphics illustrated possibilities, not property rights. My attorney then filed one final motion asking the court to award reasonable attorney fees and require correction of the public representations that had caused the dispute. The judge granted the request, explaining that the litigation became necessary only because recorded ownership documents had been ignored for years despite repeated written warnings. He also ordered that all inaccurate references suggesting Homeowners Association authority over my island be formally withdrawn. Several weeks later, the marina looked peaceful again. Boats still crossed the water every morning, but now they respected the property boundaries that had always existed. The resort remained open, although its signature attraction had changed completely. Instead of promising experiences it could not legally provide, it began promoting the features it actually owned. Surprisingly, the resort eventually contacted me with a proposal based on mutual respect rather than assumptions. They asked whether I would consider discussing limited future partnerships under terms we could both voluntarily negotiate. For the first time, the conversation began with honesty instead of entitlement. I agreed to listen because cooperation built on truth is always stronger than conflict built on misunderstanding. Looking back, I realized the most valuable lesson had nothing to do with courtrooms or expensive developments. The greatest protection any property owner has is not anger, influence, or loud arguments. It is accurate records, patient investigation, and the willingness to let verified facts speak louder than confident assumptions. My island never moved, my deed never changed, and the truth never became more powerful than it had been on the first day. It simply waited for someone to read the documents carefully enough to see what had been there from the beginning, proving once again that lasting justice does not come from revenge. It comes from the quiet strength of the truth finally being recognized.